What we have so far is a court of appeal. A court of appeal which can hear cases from the state system and cases from the federal system. We know that its members are picked by the president. We know that it's a court which can choose which cases it will hear. We know that it's a court in which interesting intellectual constitutional debates happen. What we still don't know is why the Supreme Court is so important. It's important because it has the power of judicial review. Let me explain this. It all started with a case, Marbury, John Marbury. This is Madison in 1803. At that time, the Supreme Court was a minor part of the federal government, defined in the Constitution, but it played a very minor role. In 1800, John Adams was beaten by Thomas Jefferson in the presidential election. But before leaving, Adams nominated judges for federal courts. He chose his friends and made them judges, using his nomination power. As you can imagine, Thomas Jefferson and James Madison, his US District Attorney, le ministre de la Justice in France, they were not happy with that. So they chose to ignore these nominations. They said, well, we are not going to have friends of the defeated candidate act as federal judges, of course. They decided to ignore the nominations. But James Marbury, one of the people who would have become a judge, was unsatisfied. He was expecting to become a judge. And there you had the president and and James Madison denying him this position. So he appealed to the Supreme Court because under a 1789 judicial law, the president of the Supreme Court had the power to validate the nomination of federal judges. And that was a problem for the Supreme Court, because on the one hand, they had Thomas Jefferson. On the other, they had John Adams on opposite sides. And they could judge in favor of one or in favor of the others. But in any case, they would appear to be partisan. They would give a victory to one camp or the other. So John Marshall found an original solution. He gave away a power and created a much more important one for his court. The court refused to confirm or infirm the nomination of Marbury. It said that 1789 law was unconstitutional because it did something which a law could not do. That law, that 1789 law, violated the Constitution. If it violated the Constitution, it cannot exist. Therefore, we do not have to confirm Marbury's nomination. The Supreme Court renounced its power to confirm a judge's nomination. It said, well, all right, we cannot do that. But it's a minor power. At the same time, the court created a new power for itself, the power to check if a law is constitutional or not. And that is the power of judicial review. The principle, as written in 1803 in the opinion on Marbury v. Madison, is very clear. A legislative act a law or an executive decision, a legislative act contrary to the Constitution is not a law. It is emphatically the province and duty of the judicial department to say what the law is. So A, if it contradicts the Constitution, it's not a law, and B, it's a Supreme Court's role to say if something is constitutional or not. The Supreme Court can therefore invalidate a law after it has been written and approved by Congress, after it has been signed by the President. However, the Supreme Court cannot decide to look at a law. The case has to come through the judicial system. Someone has to go to a state or federal court and have a legitimate complaint. Someone has to lose something because of the law, file a complaint, and eventually it will go from state court to appeal court to state Supreme Court to US Supreme Court. And there the Supreme Court will have a look at the law and decide if it's constitutional or not. An example, the Line Item Veto Act. 1996, the Republican Congress gave a new power to President Clinton. There was a law, an act, and it gave Bill Clinton the power to veto not entire bills, but certain lines in appropriation bills, budget bills. In budget bills, appropriation bills, usually you have huge sums of money given to the executive branch. But some members of Congress will add gifts for themselves or for people they support. So for example, a Republican from Arkansas could add a line in an appropriation bill saying, and then we'll build a bridge in Arkansas, and we'll give money to the firefighters in New York, etc., etc. So huge budget bills and small lines, small items, giving money to some organizations or some parts of the country. To fight this, it was decided that it would be good if the president could just veto these gifts, these small lines, these small gifts to certain organizations. The court, the Supreme Court, could not just decide to have a look at the law. So, four Republican senators tried to go to the Supreme Court and say that they had lost power because of the new law. So the Supreme Court said no, it refused to examine the case, saying that they had to prove that the law would hurt them. But eventually, the City of New York, hospital associations sued because they had lost money when the president vetoed one of these gifts, one of these lines. And that went to the Supreme Court. The Supreme Court heard the case and said, this law contradicts the Constitution. The Supreme Court said, this is what you have in the Constitution. It describes the right, the power of veto, the right for the president to veto a bill. If he approves the bill, he shall sign it, but if not, he shall return it with his objections to that house in which it shall have originated, who shall enter the objections at large on their journal and proceed to reconsider it. The Constitution says that the president can veto a bill, it does not say that the president can veto a part of a bill. Therefore, the law contradicts the Constitution. It is unconstitutional. That does not mean that you cannot give this power to the president. But if you want to give this power to the president, you have to change the Constitution. And you remember that amending the Constitution is much harder than passing a law. And that is the reason why the Supreme Court is so important. Because whatever Congress does, the Supreme Court can undo it if it judges it to be unconstitutional. So of course, when the Republicans in 2005 already had the White House, right here, and the Capitol, they had the presidency and a majority in Congress. Well, of course, they wanted to have the Supreme Court as well, collect the entire state, the three branches of government. Right now, the Republicans do not have the presidency. They have a majority in their House of Representatives, but they do have the Supreme Court. Once in a lifetime opportunity. Place your nomination now, of course. If we come back to this diagram of checks and balances, you're familiar with all the gray arrows. What can the judicial branch do? It can review executive orders. So if the president gives an order, the Supreme Court can have a look at it and declare it to be unconstitutional. And it can do the same with laws passed by Congress. That is the main power which the judicial branch has. This power in the 20th century. If we have a look at the Supreme Court in the late 19th century, it was a very conservative institution. It was, in particular, in favor of segregation. You remember that there had been constitutional amendments to give black people the right to vote and to redefine citizenship after the US Civil War. The Supreme Court in 1896, in the infamous Plessy v. Ferguson decision, decided that it was constitutional to have a separate but equal doctrine. Segregation, in other words, black and white people were equal, but it was okay to have separate restaurants, separate schools, etc. Later on, in the early 20th century, the Supreme Court opposed Roosevelt's New Deal, considering that the president was trying to seize too much power. And we've seen in the previous lecture that to a certain extent, it's true that the president did increase its powers a lot at that time. A contemporary cartoon illustrating this conflict between the Supreme Court and Roosevelt, it was resolved through compromise mostly. Well, gentlemen, is any of my legislation before the court today? Says Roosevelt, towering over the Supreme Court of the United States, over the small man in black in the United States. And surprisingly, in the 1950s, Eisenhower nominated Earl Warren to be Chief Justice of the Supreme Court. Earl Warren was supposed to be a conservative. He turned out to be a liberal, someone who was willing to reform the country. And the Supreme Court, which had been very conservative, became an active political force. In particular, it worked for desegregation. A famous case, which you must know, is a Brown v. Board of Education case of 1954. In this case, parents filed a complaint because they opposed segregated schools, which had been declared constitutional by the Plessy v. Ferguson case of 1896. So parents sued, and they were helped by the civil rights organizations, in particular the NAACP, that went to the Supreme Court. It was actually a series of cases which went to the Supreme Court, and the Supreme Court, in a unanimous decision, decided that the separate but equal doctrine was no longer valid. Roe v. Wade, and you'll have a link to the documentary, is a case through which the Supreme Court made it impossible for states to prohibit abortion during the first 3 months of pregnancy. Before 1973, there was a law in Texas which made it impossible for women to have an abortion. After 1973, no state could prohibit abortion during the first 3 months. That was based on the 14th Amendment, the right to privacy, and it was a major decision. 46 state laws were made unconstitutional by this decision. 46 state laws. So the Supreme Court went against the status quo. They went against conservatives. They went against traditions in the state to establish this right to abortion for women. And this is something we still have in political campaigns, something that is debated whenever you have a Republican candidate. It is asked about Roe v. Wade. It is asked about his position on this debate.